General Kagan, I really liked something you said yesterday in your conversation with Senator Kyle. You said that one of the glorious things about courts is they provide a level playing field in all circumstances, and that we need to make sure that every single person gets the opportunity to come before the court and gets the opportunity to make his best case and gets a fair shake. I want to discuss something that is denying more and more working Americans that precious day in court, that fair shake, and that's mandatory arbitration. Now, arbitration has its place, but I'm talking about mandatory arbitration. Chances are, if you have a cell phone or a credit card, or if you work, you're likely to have signed a contract with a mandatory arbitration clause. These clauses basically say if we violate your rights, you can't take us to court. You have to take it to an arbitrator. But then the fine print essentially says an arbitrator that we pay, who depends on us for work, and who makes decisions in secret. So a lot of people are denying their opportunity to come before the court. Unfortunately, we've seen a series of decisions from the Supreme Court that have made it even harder for people to get that fair shake, as you put it. In 2001, in a case called Circuit City, the court was asked to decide whether workers' employment contracts could be subject to mandatory arbitration. This really should have been a no-brainer because the Federal Arbitration Act of 1925, the law that says which arbitration agreements should be enforced, specifically exempts, quote, contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. Organized labor had asked for this specific language to be included to make sure the act would not apply to workers' employment contracts. In fact, then Commerce Secretary Herbert Hoover said during a Senate hearing, quote, if the objection appears to the inclusion of workers' contracts in the law's scheme, it might well be amended by stating, but nothing herein contained shall apply to the contracts of employment of seamen, railroad employees, or any other class of workers engaged in interstate commerce. Secretary Hoover was saying that if Congress wanted to make clear that the Federal Arbitration Act did not apply to employment contracts, Congress should put this language in the statute. So Congress put the language in the statute. But when Justice Kennedy wrote the majority opinion in Circuit City, he ignored the history. He wrote, and I quote, we need not assess the legislative history of the exclusion provision. Let me repeat that. We need not assess the legislative history of the exclusion provision. And based on a strained reading of the law, he decided that the exception only applied to workers in the transportation business, not any class of workers. This means that instead of all workers getting their day in court in Congress, like Congress clearly intended, only transportation workers would get it. And that excludes the vast majority of American workers. General Kagan, I really disagree with this case and the way the court ignored Congress's intent. That's why I was glad to hear your response to one of Senator Schumer's questions about how the court should interpret statutes. You said that, among other things, quote, I think a judge should look to the history of the statute in order to determine Congress's will. General Kagan, we spent a lot of time in hearings and on the floor debating legislation. How much weight do you think a judge should give to the deliberations of Congress and the reasons why we passed a law in the first place?
Well, Senator Franken, the most important thing in interpreting any statute In fact, the only thing that matters in interpreting any statute is Congress's intent. Congress gets to make the laws under Article 1 of the Constitution. And what the court should be doing in applying those laws is trying to figure out what Congress meant and how Congress wanted the laws to be applied. And that is the only thing that the court should be doing. Now, sometimes that can be a difficult task. New situations come up. The statutory language, it's not clear how the statutory language applies to those new situations. Or sometimes Congress might simply not have thought of particular situations. Language is, by necessity, inexact. And so there are going to be cases which...
Do you agree with Justice Kennedy, we need not assess the legislative history of something?
I would say this. I would say where the text is clear, a court should go with the text. Where the text clearly covers some situation, the court should do that. The court should not rewrite the law.
But shouldn't the court assess that, make an assessment there?
Well, I think if the text is clear, the court should not rewrite the law. But where the text is ambiguous, which often happens.
And wouldn't you have to assess whether it's ambiguous?
Yes, I mean, the first step
so what Justice Kennedy said doesn't quite stand up to that, does it? Let me move on that. We in Congress, we want to make sure, all of us, that our intentions are clear, so that 75 years from now, the Supreme Court doesn't just ignore the purpose behind the laws we are passing. How can we do that? How do we do that? How do we do that? How do we make it clear to future justices?
Well, the courts surely would be helped if Congress spoke as precisely and exactly and as comprehensively as it could in all situations. You know, there are some instances where the court just has legitimate difficulty trying to figure out what Congress intended, and where judges, all of whom agree that what they should be doing is doing what Congress intended, have difficulty determining that or disagree about what that means. And certainly to the extent that Congress can make its intentions clear in legislation and can specifically spell out how it intends for the law to operate, Congress ought to do so. And of course, you know, to the extent that the court gets something wrong with respect to a statute, and this has happened, you know, many times in recent years and in prior years as well. To the extent that the court gets something wrong, of course, Congress can come back and change it and make clear that the court got it wrong, and also use it as an opportunity even to make clear its intentions with respect to a general area of law.
Okay. It's hard to do 78 years from now, but we'll try. Circuit City was a Rehnquist court decision. Just last week, the Roberts Court did Circuit City one better in helping employers keep their workers out of court and into arbitration. It happened in a case called Rent-A-Center v. Jackson, which Senator Feingold noted yesterday. Rent-A-Center had 21,000 workers and hundreds of millions of dollars in annual profits. It also forces its workers to sign a mandatory arbitration agreement as a condition of employment. Antonio Jackson, an African-American account manager in Nevada, had been working for Rent-A-Center for years, but he was frustrated because he watched his company pass him over for promotions again and again. Instead, they promoted workers who had less experience and who weren't black. Although Jackson signed an employment contract agreeing to arbitrate all employment claims, this seemed blatantly unfair, and he sued Rent-A-Center. But the company argued that only the arbitrator could decide whether the arbitration clause was unfair. Let me repeat that. Rent-A-Center argued that only the arbitrator could decide whether the arbitration clause was unfair. Last week, the Roberts Court sided with Rent-A-Center. Talk about not getting your day in court. Now you can't get your day in court to get your day in court. Now, General Kagan, I know I probably can't ask you about whether you think this case, well, I can ask you, but you won't answer, whether this case was correctly decided, but I would like to ask, do you still agree with what you said yesterday to Senator Kyle, that one of the glorious things about courts is that they provide a level playing field in all circumstances, and that we need to make sure that every single person gets the opportunity to come before the court and gets the opportunity to make his best case and gets a fair shake?
Well, I do agree with that very strongly, Senator Franken. And if I might just return to this question of statutory interpretation that you started off with, because I did want to make clear that when a text is ambiguous, which frequently happens, that I think that the job of the courts is to use whatever evidence is at hand to understand Congress's intent. And that includes exploration of Congress's purpose by way of looking at the structure of the statute, by way of looking at the title of the statute, by way of looking at when the statute was enacted and in what circumstances, and by way of looking at legislative history. Now, I think courts have to be careful about looking at legislative history and make sure that what they're looking to is reliable, but courts should not at all exclude signs of congressional intent and should really search hard for congressional intent when the text of the statute itself is unclear.
Good. Then I think you and I agree that Justice Kennedy may have been in error when he said that the court doesn't have to assess the legislative history.
Well, I suspect that I don't know the case very well. I suspect that Justice Kennedy may have meant that he thought that the text was clear, and therefore the legislative history was not something that should appropriately be explored. But I'm just guessing on that.
Okay. I think you're guessing wrong.
Okay.
General Kagan, you've gotten a lot of questions about,
It's not the first time in my life.
and nor the last, we all guess wrong. You've gotten a lot of questions about Citizens United. I'm going to try to bore down a little deeper on this. First, I want to make it totally clear that a full 80% of Americans who hear about this case just think it's a bad idea. The first problem is the impact it's going to have on our communities and our ability to run those communities, because the potential for corporate influence on our elections under Citizens United is going to dwarf what it is today and may very well totally drown out individual citizens. Before Citizens United, if a corporation wanted to run an ad that said vote for Joe, it could only use money from its political action committee, or PAC. Those PACs relied on donations from employees and executives, individuals in those corporations. In the 2008 cycle, all federal PACs combined spent a total of $1.2 billion. Now, after Citizens United, if a corporation wants to run an ad that says vote for Joe, it can use all of its money. Its treasury funds, its revenues, all of its money. In the 2008 cycle, the combined gross revenue for Fortune 100 companies was $13.1 trillion. Now, obviously, they're not going to spend all that money on ads or all of it on just any election. They would spend a lot, but they can spend billions. They could have spent under this law billions when we passed the law that took the lead out of gasoline, when we passed the law that required seatbelts. And they are going to spend it when we try to protect against oil drilling in deep water when we don't have safety precautions, or Wall Street fraud. They're going to spend their money against the consumer and environmental laws to protect our families and our homes. General Kagan, this is one of the last things that Justice Stevens said in his dissent. At bottom, the court's opinion is a rejection of the common sense of the American people who have recognized the need to prevent corporations from undermining self-government since the founding. What do you think that means, General Kagan?
Well, Senator Franken, when I argued the case, I thought that the strongest argument of the government was the very substantial record that Congress put together, which I think reflected the sense of the American people, that these monies from these actors spent in this form could have substantial corrupting effect on the political process. And that's the argument that the government made to the court. Now, as I've indicated before, I approached this case as an advocate, not as a judge, and that there are certainly strong arguments on the other side as well. And in particular, there is the fact that political speech is the highest form of speech under the First Amendment, entitled to the greatest protection, and that the courts should be wary of Congress regulating in this area in such a way as to protect incumbents to help themselves. And I think that those are strong arguments. The argument that the government made in defense of the statute as against that was really an argument about the strength of the governmental interest involved in this case in preventing corruption from this kind of expenditure of money.
General Kagan, another problem with Citizens United was how it was decided. Because it was decided in a manner that was really unfair to the American people. Let me explain. When you go to trial, you make arguments and you introduce evidence to back up those arguments. Now, you can't introduce evidence after trial. So if you appeal, you can't just come up with a new argument because the appeals court doesn't have any evidence to decide it on. This is why there's an old rule that the Supreme Court shouldn't answer questions they aren't asked, or as Justice Scalia said to you in your first oral argument on this, we are not a self-starting institution. We only disapprove of something when somebody asks us to. If the court expands the scope of the question before it, this is me, it won't have the evidence it needs to decide that question. But that's the opposite of what the court did in Citizens United. In Citizens United, the plaintiff argued and presented evidence on this question. Should a certain part of McCain-Feingold apply to certain kinds of nonprofits? And that's not the question that the Roberts Court answered. This is how the Roberts Court answered. No, McCain-Feingold shouldn't apply to nonprofits or for-profits or unions. And neither should a different law that Congress passed 40 years ago. In fact, both of those laws are unconstitutional for everyone. Because the Roberts Court answer to the question wasn't asked, it never got evidence on how McCain-Feingold was actually affecting most nonprofits or any for-profit corporation or union. This is what you said in the case, in your argument. What the government, or this is what you said actually here in the hearing. What the government tried to argue in Citizens United was that Congress had compiled a very extensive record about the effects of these expenditures by corporations and unions on the political process. And what the Congress had found was that these corporations and unions had a kind of access to congressmen, had a kind of influence over congressmen that changed outcomes, and that was a corrupting influence on Congress. That was a many, many thousand-page record. So this finding of fact was ignored because it had to be. As Justice Stevens said, the record is not simply incomplete or unsatisfactory, it is non-existent. General Kagan, you were criticized at the beginning of this for being outcome or results-oriented, especially in your bench memos to Justice Marshall. How's this for guaranteeing an outcome? You wait until the case is out of the trial court. You wait until it is too late to submit evidence. You wait until the institution that wrote the law can no longer submit evidence. You wait until the appeal has been argued in the circuit court. You wait until the oral argument before the Supreme. You wait until the oral argument before the Supreme Court, and then you change the issue under consideration to get the outcome you want. If that isn't outcome-oriented, I don't know what is. I'd love to ask you if you agree, but I don't want you to force you to criticize your future colleagues. So instead, let me see if you agree with some general statements of law. In general, do you agree with Justice Scalia that the Supreme Court is not a self-starting institution that should only disapprove of something when somebody asks it to?
That's certainly true. It's a basic postulate of the way we run our judicial system, that the court doesn't issue advisory opinions, that the court doesn't issue opinions on anything except what's necessary to decide a concrete case or controversy before it.
Okay, how about this? Here's something that Chief Justice Roberts said when he was a circuit court judge. He said, if it is not necessary to decide more, it is necessary not to decide more. You agree with that?
I do agree with that, Senator Franken. That too is a basic principle of our legal system,
So,
and it's a requirement of, or it's a foundation stone of judicial restraint.
well, I'm glad you agree with that. You agree with Chief Justice Roberts that courts should decide matters as narrowly as possible.
Yes, I do, Senator Franken, in part for the reasons I was discussing with Senator Whitehouse, that this leads to a kind of restrained decision-making in which consensus can be most easily achieved and appropriate and restrained outcomes most easily reached.
Okay. I would be the last person to draw conclusions from your answers. But to be honest, in Citizens United, I don't think Justice Stevens or, Justice Scalia or Chief Justice Roberts adhered to their own principles. I think they were legislating from the bench. I want to talk about a lot of people talked about Exxon, but there are a couple of other Supreme Court decisions that dramatically weakened our ability to protect the environment. Senator Feinstein asked you about one of those cases yesterday, the Rapanos case, and you said that you weren't familiar with it, so let me just summarize it very quickly. In Rapanos, the Supreme Court looked at what kinds of wetlands are protected in the Clean Water Act. After Congress passed the act in 1972, the EPA and the Army Corps of Engineers passed regulations to enforce it. Basically, the act said that it covered navigable waters. But the Army Corps realized that to protect those navigable waters, it also had to protect the wetlands and streams that fed into or were near those navigable waters, because it's water. And so they did. The Corps extended coverage to those waters too. But in Rapanos, the court struck down these regulations because it said they were too broad, even though they had been in place for up to 30 years and were actually necessary to protect America's water. And this water is what people drink, people catch fish in, and that our kids swim in. Now, thanks to this case and a similar case known as Swank, the Clean Water Act now doesn't cover half of the nation's largest polluters. And thanks to these cases, a lot of western Minnesota is outside the protection of the Clean Water Act, and so is a large part of the Gulf Coast. Yesterday, you discussed the Chevron doctrine with Senator Feinstein. As you explained, Chevron says that the courts should generally defer to agencies and their regulations because, quote, Congress would have wanted that the entity with political accountability and expertise to make the decision rather than the court. So let me ask you a few questions. General Kagan, can you tell me how many of the Supreme Court justices have a degree in the environmental sciences?
Well, gosh, I don't know, Senator Franken.
I don't
I'm
either. I think it's
assuming-
none. Though.
Okay.
Can you tell me I have a degree in public health? We're going to both guess together.
I'll guess none.
That's what I would guess too. Now, of course, the court has to make decisions in areas where they don't have expertise or personal knowledge. But when they rewrote the Army Corps of Engineer regulations on wetlands, the Roberts Court didn't have any special subject matter expertise on that issue. General Kagan, what does Chevron protect? If it doesn't protect regulations issued 30 years ago that were never questioned by Congress and were enforced repeatedly during that period.
Well, Senator Franken, Chevron says that where there is ambiguity in a congressional statute, where there's not ambiguity, you just go with what the statute says. But where there's ambiguity, that an agency's interpretation of what Congress intended for a statute to mean should receive deference from the courts. And the idea really is that the agency is better able to clarify that ambiguity because it has a kind of expertise in the area, and also because it has real political accountability through the president. And the courts have neither expertise in one of these various technical subjects, nor do the courts have electoral legitimacy. The courts are, by design, cut off from the people. So for both competence reasons and legitimacy reasons, Chevron says, as between courts and agencies in interpreting unclear statutes, you should give the nudge to agencies, that courts should defer to their decisions. It's actually a Justice Stevens opinion. I think it's one of the most cited cases, maybe the most cited case in Supreme Court history.
And yet, in this case, the court didn't give deference to that, did it?
Senator Franken, as I indicated to Senator Feinstein, I haven't read this opinion ever. I think that this might be one where the court...
If you trust me on my description of it, would you... never mind. Why would you do that? Okay. Let's say my description was accurate. Does it strike you that maybe they didn't give proper deference? I mean, I know that's
Senator Franken, this
hypothetical that my description would be accurate.
I've been an administrative law professor, and
Yeah.
Chevron is actually something that I've written a good deal about, and I think I've written about it in a beyond the fact that Chevron is obviously settled law going forward. I have to say, if you look at my writings on administrative law, you know that I'm a sympathizer with Chevron for the kinds of reasons that I just suggested.
Thank you for your indulgence. And I have a minute 15 left, and you know what? I'm going to yield that time.